A special bench of the Supreme Court comprising Chief Justice of India SA Bobde and Justices Sanjay Kishan Kaul and Suryakant today reserved its orders on a petition filed by the NGO Lok Prahari seeking the appointment of additional judges or ad hoc judges to the high courts all across the country in consonance with Article 224A of the Indian Constitution. While perusing over the suggestions put forth by the Attorney General K.K. Venugopal, Chief Justice of India S.A. Bobde primarily observed that a position of an ad hoc judge cannot be made vulnerable, especially with regard to its removal procedures. The Chief Justice of India S.A. Bobde observed that there are often complaints made against judges of the Indian judiciary which are at times shockingly false, and that the position of such judges cannot be made vulnerable. Justice Sanjay Kishan Kaul added to this and said that if one or two ad hoc judges are appointed, then there will be 200 more who would say what problem those two judges actually have and why weren't the others selected. The three-judge bench has today also clarified that the salaries and allowances for these ad hoc judges will be made applicable from the Consolidated Fund of India. However, upon the request of Attorney General K.K. Venugopal, the particular case by Lok Prahari will not be disposed of and will be kept pending, and the bench would only pass an order regarding the appointment of ad hoc judges. The top court today heard a petition by the Supreme Court Women Lawyers Association in which they had written a letter to the Chief Justice of India S.A. Bobde and other judges seeking appointment of women Supreme Court judges to several high courts and certain amendments to the memorandum of procedure so that women judges who are not at all appointed in certain high courts be given priority from the Supreme Court Women Lawyers body. The Chief Justice of India, while hearing this petition, did not issue notice but observed that there have been instances where the Chief Justices of various high courts have personally informed him that often when women lawyers are elevated to the bench as judges, they cite difficulties such as parental obligations or domestic responsibilities and refuse to take up the role of judgeship. The three-judge bench also observed that it has only the best interest of the women lawyers and judges in mind, and that it was certain that the time has come for a women Chief Justice of India, and that it was only awaiting a capable candidate. Well, an important judgment today, the Supreme Court of India today held that balance sheets can amount to acknowledgement of debt under Section 18 of the Limitation Act. The judgment was delivered by a three-judge bench of Justices Rohinton Nariman, B.R. Gawai and Rishikesh Roy. The judgment was delivered in a plea challenging a judgment of a five-member bench of the National Company Law Appellate Tribunal, which had refused to re-examine the correctness of an earlier judgment in V. Padmakumar versus Stressed Assets Stabilization Fund. In V. Padmakumar, the issue was whether reflection of debt in the books of accounts tantamounts to acknowledgement of debt under Section 18 of the Limitation Act 1963 and thereby extends the period of limitation. A Justice A.M. Khanwilkar-led bench of the Supreme Court today ordered a CBI probe in the Indian Space Research Organization scientist Nambi Narayanan's wrongful arrest case in the ISRO Espionage matter. Supreme Court noted that the sealed cover report submitted by former Supreme Court Judge Justice D.K. Jain had called for a CBI probe and a deeper investigation into the matter. As per the Supreme Court order, a copy of the sealed cover report would be given to the Solicitor General of India, Tushar Mehta, and one would be sent to the CBI. And media would not be able to access the sealed cover report till the CBI finishes its probe. The CBI has been directed to submit a report to the top court within 3 months of its probe. Nambi Narayanan was a scientist at ISRO and was in charge of the cryogenics division. In 1994, he was falsely accused of leaking defense secrets to enemy countries and was arrested by the Kerala police under the Official Secrets Act. Well, as a particular hearing in the Court of Justices D.Y. Chandrachud and MR Shah progressed in the afternoon, Justice MR Shah announced in the open courtroom that his entire staff has been detected positive with COVID-19. After saying this, the bench broke for about 10 to 15 minutes and again reassembled at 2 p.m. Justice MR Shah then observed that it was indeed difficult times and that he was fine and the hearing would go on. Justice Shah's statement comes close on the heels of several Supreme Court registry staff testing a COVID-19 positive in the second wave of the coronavirus infection since last week. Well, that's all from Supreme Court today. Do stay tuned with Supreme Court today tomorrow as well. And don't forget to like and share baranbench.com.